All right, this is case number 07133-860. This is Asset Acceptance LLC versus Theodore R. Johnson. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case by default on the 14th of November 2007 for $3,306.90. The record should further reflect that judgment was renewed on the 14th of August of 2017 for the and judgment was entered for the same amount as a renewal judgment. The record should further reflect that throughout the document there are a number of motions or a number of writs for garnishments regarding income tax refunds, and more recently a garnishment was filed. It looks like sometime in the month of June of 2022. A garnishment for non-periodic garnishment was filed at that time. Objections was filed there too, and that is the basis of this hearing. Your appearance for asset acceptance at this time, please.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
All right, thank you, counsel. Your P number, if you will, for the record.
Yes, Your Honor, 71348.
All right, thank you, counsel. And do I have Mr. Theodore Johnson on the Zoom at this time?
Yes, Your Honor.
All right, good morning to you, Mr. Johnson. I know that that this is your objection to the writ of garnishment. You prepared the form and indicated that your basis for the objection is that the writ is not properly issued, otherwise it is valid. Point out that it's 13 and 14 years old, and that the statute of limitations has run, and that they should not be able to proceed.
Yes, sir.
All right. Anything else you wanted to tell me at this time?
Yes, sir. I lost visual on you. Is that okay?
I'm sorry?
I lost visual contact, but is that okay?
Yeah, I mean, you should. I'm still,
Okay, now you're back.
I
Okay.
can see you and I hear you. I hear you fine. Go ahead, sir.
Yes, sir. I received a notice from the company Midland, which indicated that their intentions was to file a writ against me. It was dated February 13th, 2020. I responded with a letter to notify them that I was responding within that 30 days and that they should cease in the collections against me.
You froze up there, Mr. Johnson. You still there, sir?
Never responded. And
Yeah, Mr. Johnson, you broke up a little bit. You were telling me about a letter, a 30-day letter you sent in March, in 2020, asking or demanding that they cease collections, that you never received a response to that notice. Is that correct, sir?
yes, sir, I followed within that 30-day period and they never responded. So the next response I got from them was the garnishment, which was in the 2000, right in October. Now it was dated 11/5/21.
All right. All right. Anything else, sir?
Other than I kept trying to contact them and they never responded, just with the legal paperwork for the garnishment.
All right, sir. Counsel?
Your Honor, per MCR 3.101K1, the only valid basis for an objection to garnishment is to show some defect or irregularity in the garnishment proceeding or the actual garnishment itself. I'm not aware of any requirement that the plaintiff is required to respond to the defendant's request for information on the garnishment. It's my understanding garnishments are filed with the court and they're sent to the employer, or in this case, I believe it's the state of Michigan for a tax garnishment. And at that point, the defendant can file an objection to the garnishment and point out some irregularity or defect to the garnishment, whether or not the funds shouldn't be withheld or the balance is paid in full or something along that nature. And I'm not hearing that here, Your Honor. So based on the court rule, I would ask that the objection to garnishment be denied.
All right. So it seems to me what's going on. First of all, the objection is raised setting for an issue of statute of limitations. There's not a statute of limitations issue in this case. This judgment was entered long ago in 2008, as I previously indicated. And then by law, it was renewed in 2017. And so the judgment remains in place and it is a valid judgment. Defendant indicates to me, Mr. Johnson indicates to me that he sent a notice out to cease collections. It sounds like that was something that was offered as an effort to stop the collection proceedings prior to there being any in-court action. There is no notification that can be sent to a creditor that has a judgment against you demanding that they stop collection proceedings, where by law they have the right to use collection proceedings because they have a judgment that's in place. And that's the challenge here, is that judgment in place, as long as that judgment is in place, the plaintiff has the right to proceed and collect on that judgment, notwithstanding any notification that may be given to them that you no longer wish for them to collect, or that you're raising the issue of some federal statute. There's a judgment. If you wish to find a way to stop the collection effort, then you would have to find a way to either have the judgment set aside or to have some other superseding order that does not allow the collection. And typically that type of order involves some type of bankruptcy or something. None of that is the case here. And so I don't see a valid objection here in regard to this matter. It seems to me that given the fact that this judgment has been around for a significant period of time, that it might be worthwhile to talk about a way for the parties to reach some resolution to resolve it. But as long as that judgment is in place, the plaintiff has the right to collect on the judgment. And again, there's no statute of limitations issue because the case was filed back in 2007, and the judgment was entered in 2008, and then by statute the judgment was renewed in 2017. So for all those reasons, I don't see a basis in law for the objection to the garnishment, and so I'll deny the objections at this time, because I don't see a basis for the same. This seems like an issue regarding the Michigan State Treasury. It doesn't seem to be a wage garnishment, but still, the plaintiff has the right to collect as long as that judgment is in place. So that is my order. I don't see a basis for the objection, so I'll deny the objections and allow the garnishment to go forward because there is a valid judgment that remains in place at this time. That is the court's order. I will sign an order consistent therewith, and that order will be sent out to the respective parties in herein. I do wish you well, Counsel Mr. Johnson. Wish you well, sir. Good day to the two of you.
Thank you, Your Honor.
Thank you, Judge.
The court now calls case number 18-169-305. This is Oakland Community College versus Canale Cannon. The matter is before the court on the filing of objections to a writ of garnishment. The garnishment is in regard to Child Care Incorporated. The record should reflect that a judgment was entered in this matter by default on the 30th of November 2018. The judgment was based upon an affidavit submitted to the court indicating that the defendant had been served. That judgment was entered for $1,594. Subsequent to that time, there were writs of garnishment that were issued in this matter in 2018, also in 2019, as well as in 2020. Then the most recent garnishment is a garnishment that's been issued as relates to an effort to collect on a wage garnishment, as opposed to the other ones look like they were income tax garnishments. All right, your appearance at this time, Counsel.
Yes, good morning, Your Honor. Dylan White, P80755 for Oakland Community College.
All right, so good morning to you. I'm looking now for Canale Cannon. Canale Cannon, it appears. If you're on the Zoom, please say something. Canale Cannon, person residing at Santa Rosa Street in the city of Detroit. If you're on this Zoom, please say something at this time. All right, matter set on for 10 o'clock a.m. It's now 10:13. The objection in this matter, counsel said, I have no knowledge of it and I was never served. But the defendant does not appear at the hearing on today's date. So given that the defendant is not here, the court will simply deny the objections where the defendant does not appear to argue on the objections. The objections be denied as invalid, and any funds withheld will be released to the plaintiff, and the garnishment will stay in place at this time.
Thank you, Your Honor.
Thank you, counsel. Good day.
You as well.
Please mute your device until your case is called. Please mute your device until your case is called. All right, the court calls case number 20-147366. This is Jefferson Capital Systems in LLC versus Brian Alford. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this case. It looks like that judgment was entered by default on the 17th of February 2021. That was after an order for substituted service was allowed in this matter. Subsequent to that time, in February, in June of 2022, a writ of garnishment was filed before this court, and objections to the same was filed, it looks like in August. All right, your appearance for the plaintiff, Jefferson Capital, please.
Good morning, Your Honor. Brian Truba, appearing on behalf of the plaintiff, Jefferson Capital Systems. My P number 61752.
All right, thank you, Counsel. Good morning to you. I'm looking now for Brian Alford III. If you're on the Zoom, please say something at this time. Mr. Alford, looking for Mr. Brian Alford. The matter was previously set on the 24th of August. The court was not present at that time, and the court set the matter over for today's date so that the defendant could be heard close in time, the parties could be heard. Looking again for Mr. Alford. It appears that the defendant has not appeared regarding this matter. Accordingly, the court will simply deny the objections where the defendant has not appeared to argue the same and find that the objections are invalid, and will allow for the release of any funds withheld to the plaintiff and the garnishment to continue until further order of the court. So ordered.
Thank you, Your Honor. Have a good morning.
Thank you. Good morning to you, sir. The court now calls case number 21-15-1527. This is Michigan First Credit Union versus Pamela Thomas. The matter is before the court on the filing of a writ an objection to a writ of garnishment. The garnishment is issued as to Extra Credit Union. The record should reflect in this matter that the judgment was entered in this case. Just one moment. The judgment was entered by consent on the 5th of August of 2021. And subsequent to that time, there have been a number of garnishments that have been filed in this matter. And then the most recent garnishment as to Extra Credit Union. All right, your appearance for Michigan First Credit Union Council.
Good morning, Your Honor. Wesley on behalf of Michigan First Credit Union, P number 80307.
All right, thank you, Counselor. Good morning to you, sir. Do I have Pamela Thomas on the Zoom? If you're on the Zoom, please say something at this time.
Yes, I'm present on the Zoom.
All right, thank you, Ms. Thomas, and good morning to you, ma'am.
Good
I
morning.
see your objections, and you've indicated that you're objecting on the basis of hardship. Is that correct, ma'am?
Yes,
And it looks like I see two objections, so I'm going to go on through these. The second objection that I see is a hardship. Sister and cousin passed away recently, and that's a garnishment regarding Ascension Genesis Hospital. So there's a garnishment against your credit union account and also against the place where you work. Is that correct, ma'am?
yes, sir.
I also see where you filed a petition for installments payments, and you're asking the court to allow you to pay at the rate of $200. You have every 2 weeks, so that would be $400 a month. Is that what you're asking?
Yes, sir.
All right, so have you ever paid under an installment plan this debt? Have you made any other payments on your own?
Prior to this, I had an arrangement with Holtzman Law, and it was $50 a month during the pandemic. However, my sister got sick, passed away. She has 5 children, so I've been, assisting along the lines with that. Up until then, I was fine, and then I got this garnishment because I kind of fell off the payment schedule. And here I am now, just got a new job and asking, can I pay the $200 every 2 weeks so they won't garnish my wages so I can continue to support my sister children and move forward and take care of this debt as well.
Gotcha. All right, so what kind of work do you do, ma'am?
I am a store processing manager.
So I see that you have on the application that your average income is $5,000 a month. Is that correct?
Yes, sir. I just got this job.
All right, good. Well, I'm glad that you've been able to press the reset button on this thing. All right, let me ask you about the extra credit in account. How much money is there?
It was like $100 and something that they garnished. And when I went downtown to do all my paperwork, she was just telling me that if I wanted to try to get my money back, I could. The money that they did take was from my nieces and nephews for school. So the lady advised me to fill out the correct form for each process.
What you're indicating to me is that at most there's less than $200 in that account, correct?
Yes.
All right. Anything else you wanted to tell me at this time, Ms. Thomas?
I'm just looking to get the payment plan set so I can move forward. And like you said, I was able to hit the reset button. I just want to move forward and take care of this debt without being garnished. I would just like to pay for it myself if possible. Just asking for another chance.
All right, counsel.
Thank you, Your Honor. Very quickly, I don't believe there's any validity to the objections to garnishment. 3.101K does state the basis for the hardship is not a basis for an objection to garnishment. However, in a productive manner, I do believe that the motion for installment payments we could work with. The $200 bi-weekly, $400 a month would be something my client would accept. Our only stipulations would we were requested be via a stipulated order to reduce garnishment. That way the funds would come directly out. There's no concern over Ms. Thomas sending the funds to us. It just comes directly out of her check, and we don't need to come back and refile motions or anything like that.
All right, so Ms. Thomas, they're saying that I would be inclined to grant your partial payment in any event. It's a reasonable and significant amount. The plaintiff is asking that be allowed by way of wage assignment, where the $200 per pay period would be taken out, or $200 bi-monthly would be taken out automatically. Is that something that, is that something that you agree to, ma'am, or that you wish done that way?
I have no problem with that, but may I ask, how do they go about doing that?
Well, it would be like a garnishment situation. So the garnishment would be reduced to $200 a pay period. So your wages would be garnished, but the max that could be taken would be $200 per pay period. The other alternative is to allow you to pay it voluntarily. You pay it on your own. You send it on your own, and you do it that way. The plaintiff doesn't want it that way, but if I allow you to do it that way, then you would have to stay on the program yourself, and if you don't, they're going to bring you to court, and then the whole thing could be set aside, and they could request fees for having to come back to court because you didn't pay as agreed. So if you believe that you are able to keep up with the payments, then I would sign the order and allow you to work at it on your own. But you face the risk that if you don't pay it, they can file a motion, ask for cost and attorney fees, or because of having to come back to court because you broke the agreement.
I feel that I'm capable of doing it on my own, but I have no problem with complying with what Michigan First is asking. I have no problem either way. I'll be able to maintain. So if Michigan First feel more comfortable setting it at an automatic payment, I have no problem with that at all.
All right, ma'am. Well, we'll go ahead and set it up. We'll go ahead and set it up that way. The only kind of concern that I raise, counsel, is sometimes employers are frustrated with having to be constantly separating money out in that way. And I noticed she just recently got employed. That's the genesis of my concern. Ms. Thomas, do you think that it's going to cause you any kind of problems? I guess is what I want to get at.
No, this is something that needs to be taken care of. And I'm just grateful for the second chance, so I can figure it out. I just lost my sister and I had to pay for her to be buried, and take care of 5 kids after. So it was a bit of a hardship for me, even though it doesn't stand for Michigan First. I understand that, but it stands for me. So.
All right, got it, ma'am. All right, so I will sign the order allowing for the $200 every 2 weeks. And what I will do is I will go ahead and set it up as a modified garnishment with a maximum withholding of $200 per pay period. To be paid to Michigan First, and then I'll send that document out to you, and you will want to take that to the agency so that they will stop with any garnishments beyond the amount already mentioned. Now, has any money been taken from you by way of the garnishment at work yet, ma'am?
Not now, no.
Okay, all right. So this will give direction to the agency as to what it is that they are to do. And so you'll get the appropriate orders from me. Now, there is the issue of the bank account. Counsel, any position that you take in that regard, I understand that it's only $100 and something.
Your Honor, our position is that there is no validity to the defendant's objection. I think, again, it is $101. Defendant does sound like she's making good money at this point, and the $101 will decrease the amount owed. There is interest running against this. So I would request that we do keep that. The court denied the objection. I believe that is appropriate in this instance, and we'd be happy to prepare the order to that effect.
All right. What I'm going to do is, given the entry of the order for automatic assignment of the $200 per pay period, I will find certainly that the objections are invalid, but under the totality of circumstances, I will set aside the garnishment with regard to the the extra credit union, and I'll return the funds to the defendant in that regard under under my order in that regard. The other order is as I previously indicated in this matter. So the parties will receive a copy of each of the orders that the court has signed. We'll get them in the mail right away. Right?
Your Honor, you will be preparing the orders and submitting them, just for clarification.
Yes, sir.
All right,
Yes, sir.
thank you, Your Honor.
As soon as you get the orders, ma'am, you want to take that wage assignment order to your employee, so that because they won't have anything saying to not start garnishing. So you're going to need to take that to make sure that they take only 200 instead of taking 25%.
Okay, so when that order is coming via mail,
Yes, ma'am.
and you want, and once I get that, I'm giving that to the correct parties and human resources to make sure that everything is done properly.
That's correct, because otherwise they will begin taking 25% out. Okay.
Okay.
If you don't.
Okay,
Okay. All right.
thank you very much.
All right. Thank you. Good day to you.
Thank you, Your Honor.
Thank you, Counsel. And the court now calls case number 21-161-489. This is credit acceptance versus Andrew Goodman. The matter is before the court on the filing of objections to a writ of garnishment. It looks like that while the judgment was entered in this matter on the 14th of September 2021 for $8,662.64. It looks like a writ of garnishment was filed back in April of 2022, and objection to the same was filed in August. The writ of garnishment appears to be in regard to, I think it's in regard to ways. I don't have the objection form. Hold on one second. Maybe.
It is, Your Honor, wages.
All right. So this is wage garnishment. All right. So your appearance, Madam Counsel, regarding this matter for the plaintiff.
Good morning, Your Honor. Attorney Ashley Notice on behalf of Credit Acceptance, P77029.
All right. Thank you, Counsel, and good morning. Good morning to you. It looks like, and well, I'm going to ask for Mr. Andrew Goodman, but it looks like I don't have him on the Zoom today. But Mr. Goodman, if you're there, please say something. Looking for Andrew Goodman, reportedly living on Mark Twain Street in the city of Detroit. It looks like he has not appeared. We did notify him of today's date and time. The time was set for 10 a.m. and it's now 10:31. So, Counsel, my inclination is to simply deny the objections. I don't have the cover sheet with the objection on it for some reason. It's not in the file.
That's okay. The objection, Your Honor, didn't have any of the box checked, so it was blank. So as for the objection, there's no reason stated. So under the court rules, that should be denied. And then he did file the motion for installment payment orders, which we did submit a response. Considering he's not here today and based on the fact that his request would be unreasonable, we would ask that the court also deny his motion for the installment payment order.
Thank you for bringing that to my attention. And I don't have that. For some reason, it hasn't populated to the file. What was he requesting by way of installment payments?
So the defendant was requesting $150 per month. The amount left on the judgment is $7,073.52. The defendant has not made any attempt to repay this until we received the valid wage garnishment. Every fund so far that we got, so so far is from either a tax garnishment or the wage garnishment, which is bringing in almost $900 per month. So I believe that his motion, when he stated he only made about $2,200 per month, was inaccurate because, I mean, if you take 900 times 4, that's over $4,000 per month. So I believe he can pay more. And the fact that this judgment is going on 2 years old and is pretty substantial, the $150 a month is just not reasonable.
All right, so you've been successfully collecting about 900 a month, correct?
Yeah, so far we've hit 3 times, and that in total has been 5, 8. We've received about $1,350 in those 3 garnishments. So yeah, about $850 to $900 per month because he's paid biweekly.
All right, here's what I'm inclined to do, counsel. I'm inclined to set the payment at $300 a month, give him an opportunity to pay that way. I would, and I might even be willing to put on the form that is to be automatic sent. Because it seems
Well,
like we did have a petition
Your
that we
Honor,
want- Yeah, go ahead, counsel. Listen.
I respect your decision and your attempts to set something, but I look at it this way. He failed to appear today. He's not here to verify his income or his liabilities, which I believe were falsely stated on his motion. We're getting $900 a month. To take $300, that is substantially lower. I would suggest that if you are inclined to do some type of installment payment order today, that it would be for at least $500 per month. I think that's completely reasonable considering the amount that's owed compared to what he's making per month in income.
Yeah, and well, given the typical wage or installments, they're usually not that high of a percentage. And you pretty much gave me information as to about where his income is and so on and so forth. And I guess one of the things I'm looking at, I haven't made a decision on this. One of the things I'm looking at is that I know that next week I'll get another motion filed. And that motion is probably going to be $150 or $200 or whatever. And the likelihood is that if it comes in, that I'm going to end up setting it at probably about $300. That's where we are. But for the time being, I will go ahead. I'll go ahead and leave things in place as they are at this time because he isn't here. I know that I guess this is the first time. Well, no, this was supposed to be heard last week, I believe, and then we set it over. So I'm a little bit concerned about individuals whose hearing was last week, and then we had to set it aside because I got stuck in California.
Oh no.
Flights got changed around, so something happened. That's the reason I wasn't here. But we'll go ahead. I'll go ahead and deny it because, like I said, he's not here, and there's nothing regarding the objections. And then we'll reset it for the next time. Maybe I'm sure I'm going to get another motion because of the amount that's being collected. He appears to be somebody that's highly collectible. So we'll deal with it. We'll deal with it when he comes back in a month or so. All right. All right.
Sounds good.
Denying the objections and denying the application for partial payments. Now, I'm certainly going to deny his partial payments without prejudice because he's not here. And I don't want to tell him that he can't even apply to try and get it lowered for 90 days or whatever. So
Sure.
We'll address it if he presents it again. All right. All right.
No problem.
Good to see you, counsel. All right. Thank you.
Thank you, Your Honor. Have a great day.
Likewise.
Thanks.
Yeah, paperwork is not in here. The motion for installment payment and the objection.
Yeah, they didn't have many. You want me to feel like you want me to say on that?
I need to get my hands on it. I'll have to.
Okay, I'll get it down.
I don't have anything to.
Oh, go off of, okay, and that was from Mr. Goodman, right?
Yeah.
Yeah, all right. Yeah.
I have one other case, but I don't see anybody up there. This is case number 22-178187, University of Detroit Mercy versus Yvonne Davis. The matter is set before the court for a hearing on objections to a writ of garnishment regarding 5 credit union. The court set this matter on for today's date at 10 o'clock p.m. It appears that the defendant has not appeared regarding this matter. And given the non-appearance, the court will then deny the objections to the writ of garnishment. And the garnishment would stand accordingly.